Hello and welcome to Courts Today by LiveLaw. Let us get to today's top legal updates. The Supreme Court has flagged concerns with the senior designation process and has referred the matter to the Chief Justice of India. Citing the order as very disturbing, the top court has suo motu stayed Lokpal's decision to entertain a complaint against a High Court judge. The Supreme Court today rejected a contempt petition alleging illegal demolition, saying that it would have entertained it if the sanction plan was shown. In the Mullaperiyar Dam dispute, the top court has asked a supervisory committee to look into Tamil Nadu's complaints against the state of Kerala. The apex court has granted bail in a PMLA case, citing trial delay and long custody, and distinguished it from a recent precedent. The Chhattisgarh High Court has upheld conviction of 4 people in 2014 Tahakwara Naxal ambush. The Delhi High Court has refused to quash a 2016 FIR against former Delhi Commission for Women Chief Swati Maliwal for naming a 14-year-old rape victim. And a contempt plea has been filed in the Kerala High Court against ASHA workers' protest outside Trivandrum Secretariat for allegedly blocking roads and footpath. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit our website at www.livelawmedia.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. In a significant development, the Supreme Court bench of Justices Abhay S. Oak and Ujjal Bhuya today expressed certain concerns with the senior designation system, which has been laid down as per 2 judgments rendered by the top court in Indira Jaising case in 2017 and 2023. The bench clarified that it was not disrespecting the 2 binding decisions and was only recording the concerns to enable the Chief Justice of India to take an appropriate decision on a larger bench reference. The concern flagged by the bench are: first, no advocate can claim designation as a right under Section 16(2) of the Advocates Act. It is a privilege granted by the Supreme Court or the High Courts. Second, the interview process for designation is limited in assessing an advocate's overall suitability, as only 25 out of 100 points are assigned to it. The permanent committee follows a points-based formula without flexibility to consider integrity, fairness, or pending complaints. Even if an advocate has professional misconduct issues, there is no mechanism to reduce marks based on reputation or conduct outside the interview. And third, the evaluation process requires the permanent committee to review numerous judgments and publications submitted by the applicant. However, it is unclear whether the 5 members, including senior judges and advocates, can thoroughly assess each submission to fairly assign 50 marks. The practicality of dedicating extensive time per candidate raises concerns. Thus, points-based assessment is not free from defects. The question is whether it can form the basis of assessment of an advocate. Raising these concerns, the bench directed the Registrar General to place a copy of the judgment before the Chief Justice of India to decide whether the issues flagged are to be considered by a bench of appropriate strength. Let me tell you, the bench delivered this judgment on issues concerning the code of conduct for advocates on record and the process of senior advocate designation. This case arose from false statements and suppression of material facts made by senior advocate Rishi Malhotra in multiple remission pleas. In the judgment, the court also outlined the duties of advocate on record, stating that AOR is fully accountable for filings, even if drafted by another advocate. The AOR must verify facts, ensure all relevant documents are annexed, and clarify doubts before submission. They cannot shift responsibility for incorrect statements to others. The court said that their duty extends beyond filing, requiring them to be prepared even in the absence of appointed counsel. In the next update, the top court today issued notice to the union government in a suo motu case initiated against a Lokpal decision which held that it can exercise jurisdiction over High Court judges. In its order passed on 27 January, the Lokpal was deciding a complaint accusing a sitting High Court judge of influencing an additional district judge and another High Court judge to favor a private company in a case. The Lokpal, headed by former Supreme Court Judge Justice A.M. Khanwalkar, ruled that a judge of the High Court falls within the scope of Section 14, subsection 1, clause F of the Lokpal Act. It was reasoned that since the High Court in question was created for a newly formed state by an act of the Parliament, it would come within Section 14, subsection 1, clause 4. Without expressing anything on the merits of the matter, the Lokpal forwarded the complaint to the Chief Justice, awaiting his guidance. And the Lokpal's order did not disclose the identity of the judge or of the state or high court. Today, a bench of Justices B.R. Gavai, Suryakant and Abhay S. Ok expressed disapproval of the Lokpal's reasoning and stayed the operation of this order. The court also issued notice to the Registrar General of the Lokpal and the complainant. The bench has injuncted the complainant from disclosing the name of the High Court judge and the contents of the complaint. Solicitor General Tushar Mehta submitted that the Lokpal's interpretation was wrong and a High Court judge was never intended to be brought under the Lokpal. The bench observed that after commencement of the Constitution, all High Court judges are constitutional authorities and cannot be regarded as mere statutory functionaries as held by the Lokpal. The Supreme Court today refused to entertain a contempt petition alleging violation of its judgment passed on 13th November 2024, which, if you recall, had barred demolitions without prior notice and a hearing. During the hearing today, a bench of Justices B.R. Gavai and A.G. Masi questioned why the petitioner had approached the Supreme Court directly instead of seeking redress from the High Court as permitted by the November ruling. The petitioner then answered that the High Court had already taken a stance on similar cases, leaving no option but to seek relief from the Supreme Court. The counsel further submitted that the petitioner legally owns the land with a registered sale deed and had only erected a tin shed on the property. Despite this, authorities carried out a demolition with just 1 day's notice without specifying the nature of the violation. In response, Justice Gavai asked to see the sanction plan of the demolished structure. However, when the petitioner's counsel admitted that he would need to take instructions on that, the bench refused to intervene. The court made it clear that had the sanction plan been presented, it might have entertained the plea. Additionally, when the petitioner sought temporary protection to take necessary legal steps, the bench declined to grant any relief. In the next update, let me tell you, the Supreme Court has directed supervisory committees set up by the Union government to hold a meeting with officials of states of Tamil Nadu and Kerala to resolve interim measures related to the Mullaperiyar Dam. The Mullaperiyar Dam dispute between these two states revolves around dam safety, water levels, and execution of Supreme Court orders from the year 2014. Tamil Nadu insists the dam is safe and accuses Kerala of obstructing the 2014 judgment, which allowed raising the water level to 142 feet and carrying out repairs. Kerala, citing safety concerns, argues that periodic reviews under the Dam Safety Act are necessary. A bench of Justices Suryakant and N. Koteshwar Singh heard the matter and referred all pending cases related to the dam's safety to Chief Justice Sanjeev Khanna for consolidation. Justice Kant remarked that some of the disputes like tree cutting, boat services, and engineer supervision seem trivial and should not require judicial intervention. However, the court still directed the supervisory committee to look into these issues. The court has ordered the new supervisory committee, with its recently appointed chairman, must convene a meeting within a week and take necessary action within 2 weeks. A report must then be submitted to the top court. And now an update on a bail granted by the Supreme Court in a money laundering case, citing prolonged incarceration and likelihood of delay in the completion of trial. The bench comprising Justices Abhay S. Ok and Ujjal Bhuya was hearing the plea of Uddhav Singh, who had been in custody for 14 months. The Enforcement Directorate had listed 225 witnesses for examination, yet only one had been examined so far. While granting bail, the court relied on Union of India versus K.A. Najib and V. Senthil Balaji versus Deputy Director, Directorate of Enforcement, emphasizing that prolonged incarceration under stringent laws like UAPA and PMLA, especially when the trial is unlikely to conclude soon, could violate the right to a speedy trial under Article 21. The Enforcement Directorate, while opposing the bail here, had relied on an order passed recently by the bench led by Justice Bela M. Trivedi in the case of Assistant Director versus Kanhaiya Prasad. This bench had cancelled the bail granted to a PMLA accused, citing non-fulfillment of twin conditions under Section 45 of PMLA. It had stated that the twin conditions for bail under Section 45 were mandatory and disapproved of the courts granting bail in such cases casually, since money laundering was a serious offence. Interestingly, in the present case, the bench has provided an explanation or interpretation of why the Justice Trivedi-led bench might have reached the decision it did in the Kanhaiya Prasad case. The court clarified that the factual circumstances in Kanhaiya Kumar's case were different, as the accused in that matter had been in custody for a significantly shorter period, that is, less than 7 months. Since the accused had not been subjected to prolonged incarceration and the trial was progressing without undue delay, the court held that principles established in Senthil Balaji and K.A. Najib were not relevant to that case. Accordingly, the appeal in this case was allowed. Moving further, the Chhattisgarh High Court has upheld the order of a special NIA court convicting 4 persons for their involvement in 2014's Tahakwada Naxal attack, in which 15 security personnel were martyred and a civilian lost his life. The division bench of Chief Justice Ramesh Sinha and Justice Ravindra Kumar Agarwal termed the Naxal attacks to be threat to national security. The court upheld the conviction of the appellants for their role in ambushing state police and CRPF personnel, rejecting their claim of false implication. It noted that around 150 to 200 Maoists carried out the attack and that finding independent eyewitnesses was difficult due to the remote location. The court emphasized that Naxalites control certain areas, making witnesses fearful of speaking out. It further noted that unlike other crimes, Naxalite offences are far more serious in nature, which are planned and executed with the intention to inflict maximum casualties, weaken the morale of the security forces, and assert control over remote and forested regions. It held that circumstantial evidence in this case clearly proved the appellant's involvement in the conspiracy. Based on witness statements and other evidences, the court has dismissed the appeal and ordered the appellants to serve their remaining sentences. In another update, the Delhi High Court has refused to quash FIR registered in 2016 against a Rajya Sabha MP and former Delhi Commission for Women Chief Swati Maliwal for allegedly revealing the identity of a 14-year-old rape victim. The minor girl had died in a hospital after a neighbor allegedly raped her repeatedly in city's Burari area in 2016. As per the FIR, the minor was forced a corrosive substance down her throat which damaged her internal organs. A notice issued to the concerned SHO had been shared in a WhatsApp group of the Delhi Commission for Women. This notice was then circulated to news channels, leading to disclosure of the victim's name. Justice Neena Bansal Krishna refused to quash the FIR registered against Swati Maliwal under Section 228A of the IPC, which prohibits publication of a victim's identity in rape and sexual assault cases. Although this section was later dropped, fresh charges were added under Section 74 and 86 of the Juvenile Justice Act of 2015. A charge sheet has now been filed in the case. Section 74 of the Juvenile Justice Act strictly prohibits revealing the identity of children involved in legal matters. The court emphasized that newspapers, magazines, news channels, and other forms of media cannot disclose any details that might reveal the identity of a child in conflict with law or a child in need of care and protection. Such disclosure, the court said, is a punishable offence. Maliwal's argument that the charge sheet filed in the FIR against her was legally flawed was rejected by the court. Also, Maliwal had filed a petition seeking an SIT investigation into the minor's rape case and the FIR related to her kidnapping after she went missing. Additionally, she had sought compensation for the victim's mother and family. On this, the court observed that charge sheets in both the rape and kidnapping cases had already been filed in 2016 and both cases were still pending trial. Since the matter was now under jurisdiction of the trial court, the request for an SIT probe had become infructuous. The court ruled that further investigation by an SIT would serve no purpose. On the issue of compensation, the court noted that 50,000 had already been given to the victim's parents by the Delhi Legal Services Authority. It further stated that the parents could apply for additional compensation under the Delhi Victims Compensation Scheme of 2018. And lastly, a contempt case has been filed before the Kerala High Court against the protest by ASHA Health Workers Association, which is allegedly being conducted by blocking the road and footpath in front of the Secretariat in Thiruvananthapuram district from 10th February. The ASHA workers have been protesting due to the low honorarium they receive and are demanding an increase from 7,000 rupees to 21,000 rupees. Additionally, they are requesting retirement benefits and clearance of pending honorarium payments. The contempt case has been filed alleging that ASHA workers have violated the court directions from June 2010, where a division bench had directed the government agencies including PWD, police, revenue and local authorities against granting any permission to hold meetings on public roads and road margins. The petitioner here alleges that the protest is being conducted day and night by occupying the footpath and road in front of the secretariat. Chairs have been placed on the footpath and road, causing obstruction to traffic. The petitioner argues that the police have a duty to remove any structures or installations blocking public roads and footpaths as per the High Court's judgment. The division bench of Chief Justice Nitin Jamdar and Justice S. Manu heard the matter and has directed the registry to place the contempt petition before the special bench for hearing.